Lawson, second question, Judge Singh presiding.
Thank you, and please be seated. Good morning. At this time, let the record reflect, we're taking up an action that is styled Commonwealth of Kentucky versus Brooks Houck. It's 23 CR 309. Present is Mr. Houck with counsel, Mr. Butler, Mr. Shoring, and Ms. Jackson. Also present on behalf of the Commonwealth is Mr. Young, Ms. Young, and Mr. Lasowski. This matter is before the court today in regard to a motion to consolidate. I have reviewed all memorandums in regard to this prior to today's hearing. On behalf of the Commonwealth, are you all going to submit any evidence today or just argument?
Judge, I'm sorry.
No, you go ahead.
Judge, we're just going to be submitting argument this morning. I think when I say we're not going to submit any evidence, that may depend on what the defense counsel submits in this case, but whether we need to show the court something in response to that. But we just intend to argue.
Okay. Mr. Butler, what about the defense? Any evidence that or testimony, anything you wish to present today, or is it argument also?
Judge, we're not going to say any witnesses, but we do have a transcript of a September grand jury report submitted. We also have a pleading that is different points that Mr. Lawson made in his statements and how they developed as well from different points. Of course, we could incorporate the disc, I guess the flash drive we gave you previously, which I believe is all showing Steve Lawson's statements. So that would be the evidence.
Okay. Okay. I guess it's the Commonwealth's motion. So are you ready to go forward, Ms. Young?
We will.
Okay.
Yes, sir.
Proceed when you're ready.
Judge, I'm just going to address a few points regarding joinder first, and I would like to have reserve some time for us to address whatever the defendant is going to bring up in his evidence that he's going to present and in his argument. But as far as joinder is concerned, there's some general principles regarding that, and I think the court is very familiar with it. But I wanted to give the court something that we didn't put in our brief, which is the issues that were raised in Samia. Samia, everybody knows, is a case about redaction and statements, but Samia offered the court something else, the U.S. Supreme Court, and what he said is, well, if you just sever these cases, then you don't have to worry about it, and you preserve my confrontation right, and we don't have to worry about whether the co-defendant statement implicates me. And here's what the court had to say to that. The court said that was too great a price to pay when someone's statement implicates the other individual. They went through all the reasons that joint trials are favored. They said joint trials encourage consistent verdicts, and they allow jurors to make more accurate assessments of relative culpability. They went on to say that joint trials preserve government resources and allow victims to avoid repeatedly reliving trauma. And finally they noted that separate trials favor the last trial defendant, who always has the advantage of knowing the prosecution case before they are tried. So in that case, the court went to great pains in order to keep the cases together. Kentucky also favors joint trials when any of the charges arise from the same set of facts, and that's what's going on here. All co-defendants are charged out of the same set of facts and the same set of circumstances, the murder for Rogers. It's not enough for a defendant just to show some prejudice in order to sever the cases. They have to show it's unduly prejudicial to be joined together. And it's not enough to show there's antagonistic defenses. In fact, that's a good reason for joinder. It's only when those antagonistic defenses mislead the jury that joinder is not appropriate. In this case, I don't think we have antagonistic defenses. At least that's what's been presented in the pleadings that we have so far. In fact, I think what we have are collaborative defenses between Steve Lawson and Brooks Houck, because the pleadings that we have in these two cases have the same misquotes, same mistakes in them. There's obviously some form of collaboration going on in those pleadings as to a joint defense. And then And Mr. Lawson, Steve Lawson's joinder pleading in which he adopted Mr. Houck's pleading on the joinder issue, it was completely directly opposite to what he had represented to the court on his other motion. So I think we have some collaboration going on here. I'm not even sure we have antagonistic defenses at this point. I'm going to let them argue whatever they're going to argue regarding the severance issue. I'm not sure what it is at this point because initially it was the 410 issue and that they needed to be able to show the statements that Steve Lawson gave and the interviews with Steve Lawson and Joey Lawson in order to prevent the things of investigative bias or this get Brooks mentality that they said they had to be able to present. Then in the second pleading that they filed, they said, we don't need to get into any of that. If the Commonwealth agrees not to present any of the statements made by Steve or Joseph Lawson, and that included, I assume they were arguing all the statements, whether they were part of the 410 or not. So I'm not sure what they're going to argue regarding that. So we'd ask some time to readdress that at the end. I think I can clear up one issue, and that's the one regarding the grand jury and Steve Lawson's grand jury. The defendant in this case has argued that Steve Lawson's grand jury, the second and third, I'm sorry, I'll take that back. The third and fourth grand jury that Steve Lawson had, because he had one in 2015, they have argued that those are a product of coercion and that his testimony in the grand jury is a product of coercion. Steve Lawson himself has not argued that. And I don't know of anything that gives them standing to suppress Lawson's statement from the grand jury when he hasn't even argued that they're a product of coercion. But if they do in fact have some standing to argue that, there are cases that talk about this type of situation. One of it is called U.S. versus Galistino. It's 617 F. 2nd 677. And that case cites Brady v. United States, which is 397 U.S. And I have the page site, which is 754 Judge. But both of those cases talk about if you're in a coercive situation as a defendant, what dissipates the coercion is advice of counsel. We use that all the time, whether it's entering a plea agreement or deciding to testify in front of the grand jury. Those are things that make that statement voluntary, including if you're giving a statement to police. That shows that the voluntariness of the statement when it's given on advice of your own counsel. When Steve Lawson appeared back in front of the grand jury that third time after he had interviewed with the police, that was on the record that he was appearing that day on advice of his counsel. Now, there's something else they've raised in the grand jury that I think we can address and that may help the court with some of the issues they've raised in their pleadings. And one of those is they've argued that we are going to seek to use this redaction in which we put the words other person in Steve Lawson's grand jury for when he refers to Brooks Houck. And we have no intention of doing that. Those are testimonial statements. We understand our obligations under redaction, and in spite of the fact that Samia gives you some leeway on that, I think in Samia is distinguishable in the sense that Stilwell's statement in that case was necessary to show the conspiratorial relationship. We have other evidence to show that conspiratorial relationship, and I don't think that it would be necessary at all to bring up statements that Steve Lawson made in the grand jury about Brooks Houck. Now, Steve Lawson's statements about himself are coming in that he made in the grand jury. So if that helped the court resolve some of those issues, and then if we could address what they're going to argue is the reason against the severance afterwards, we appreciate it.
Thank you. Mr. Butler, are you handling this for the defense?
Thank you. fun stuff.
Sure, take your time.
Oh. Maybe approach Judge.
Certainly.
Thank you. Let's just start out where legally it says, I think the court has really three parts that you have to look at it. The first part, and Ms. Young addressed it, is outside of the 410 issues, whether this case should be joined or not. Because obviously the court has issued an order on July 3rd. And that decision appears to rest with Steve Lawson as to whether or not those 410 issues are this one. And I'm obviously going to go through those. It may come to pass that that issue also lies with Joey Lawson. He has not filed some of the same pleadings. So where that stands, I don't know. Teresa's right. There is a preference for a joint trial. But I think we start with this. Prior to the rule being that we currently have, every defendant in Kentucky has an absolute right to demand a separate trial. That we deal with now came into effect and gave a preference for a joint trial. When I say a preference, that's exactly what it is. It's a preference. It doesn't mean it's required. It means the court is required to look at each individual case separately and make a determination of whether a joint trial would be unfair. The typical case that you have, in my experience with co-defendants, was that you may have a 30-minute interview. I say, Mr. Shoring helped me do the robbery. Mr. Shoring says I helped him do the robbery. And we see those redacted out. And while there's certainly prejudice to that, theoretically, that other person, Steve Shoring, could be anybody in this room. It could be anybody in the world. This is different. And I hope I can walk you through why it's different. Number one, Brooks has a constitutional right to present a defense. Our defense is Mr. Houck did not commit this crime, and if Steve Lawson is lying. And he has to be afforded a meaningful opportunity to present a complete defense. RCR 831 says that it appears the defendant is or will be prejudiced by joinder of defendants for trial, the court shall order separate trials. Going back to my first point, and that's an important one. While there is a preference, as Ms. Young said, for joint trials, if there's prejudice, the court doesn't have discretion. The rule says that they shall. This is the state of the law in Kentucky. In a joint trial, the confrontation clause plan applies even to hearsay statements offered as evidence against the co-defendant declarant himself. If the declarant does not testify, then the statement either expressly or by immediate implication tends to incriminate another defendant. Again, coming back to the first point I made. In my example, we see where I say to get out of trouble, Mr. Shoring, I did the robbery, it's all his idea. And he says to try to get out of trouble, well, I was there, but Mr. Butler, he's the one that came up with this idea. It could be anybody. In this case, if we're going to show you, there's no way that any of this can be redacted without incriminating him. And if Steve Lawson doesn't testify, we lose our confrontation clause rights to cross-examine him. That's why we even referenced in our brief that if the court was going to otherwise join these cases, we even had a discussion with him about whether it was better to waive his confrontation clause rights or due process rights. That's how important I think it is in this particular case. But here's what we believe we're talking about. So, and I think this court's very aware of this. I'm going to go through. You have Steve Lawson who testifies once or twice in a grand jury back in 2015, 2016. And in those grand juries, I can't remember it's one or two, doesn't matter. He says, I had no role in this, don't know anything about Mr. Houck. There's even a FBI sends an informant in 2020 and surreptitiously tapes Steve Lawson. And in that, and we'll go through some of that more later, he says, I didn't have anything to do with it. I don't think Brooks Houck had anything to do with this. Fast forward into 2023, the state government begins the grand jury investigation. His statements change dramatically over time. I think this court in this order from July 3rd actually used the terms wildly inconsistent statements. The September 2023 grand jury is the cleaned up, best Steve Lawson version to help the government. The first point, and we're going to try to walk through some of these. Steve and Joey Lawson were with Brooks on a drywall job when Brooks asked them to move Crystal's car. So that's one incriminating point that is brought out in the September 2023 grand jury. Next, please. Another point is that Brooks told Steve Lawson while they were talking to his work truck that he wanted Crystal gone. Obviously, very incriminating statement taken on its at face value. The alleged movements of Steve and Joey the night of July 3rd is another point that's discussed in Steve Lawson's grand jury testimony. Purpose of a 12:07 a.m. call was for Steve Lawson to tell Brooks that the car had been moved. This court is aware at 12:07 a.m. Steve Lawson called Brooks Houck in the morning of July. Brooks told Steve to say that the 12:07 a.m. call was about rental property. And finally, from our perspective, the main points of Mr. Lawson's September grand jury testimony. Ms. Brooks promised Steve all future drywall jobs in exchange for moving Miss Rogers' car. Go ahead. A confession by one co-defendant in a joint trial poses substantial risk for the other co-defendants, notwithstanding a limiting instruction. Such limiting instructions call for a mental gymnastics which is beyond not only the jury's powers but anybody else's. And we gave details about this Taylor case in our brief. As the court is aware, anytime the court has a joint trial and a co-defendant's confession or statement is being admitted, the court seeks if possible to redact statement, and the court issues a limiting instruction to the jury, telling the jury, for example, by hypothetical, you can't use Mr. Butler's statement against Mr. Shoring, you can't use Mr. Shoring's statement against Mr. Butler. Co-defendant confessions are so prejudicial that limiting instructions often don't work. Richardson versus Marks, there's an overwhelming probability of jurors' inability to follow the instructions to disregard a co-defendant's confessions. I thought this was an interesting point, and it was in the Commonwealth's brief. So in the Commonwealth's brief to the court, and Ms. Young mentioned this, I believe her assumption was that we were arguing that even in a separate trial, that we would want to get into Steve or Joey Lawson's statements to police to show that police were myopically focused on Brooks Houck. That's not our position. We don't believe that we should be in a joint trial with them. We don't believe anything they say should come into a separate trial with Brooks Houck. In her brief, or the Commonwealth's brief, they're addressing not exactly what my point is here. What they're addressing is, if we had a trial, a joint trial, if Steve Lawson is present in that joint trial, and his statements are protected by 410, statements to the police, but yet we were getting into those statements to show this bias by law enforcement to get Brooks, to convict Brooks Houck, then a limiting instruction by the court telling the jury, you can't use Steve Lawson's 410 statements against him as incriminating evidence, but you can use these statements as it may impact Mr. Houck's presumed defense in that scenario, that this is showing that they're focused solely on. And so what the Commonwealth correctly said in that scenario is, it'd be impossible for a jury to follow such an admonition, because it would be impossible for a jury to listen to all these statements and then do this mental gymnastics like the Taylor case talks about and say, well, I can use it as it may show that the law enforcement was really focused only on Brooks, but I can't use it because it's incriminating against Steve Lawson, because there's too much of it. There is, I think I'm right about this, I believe there's over 20 hours of interviews just with Steve Lawson beginning in June of 2023, not to speak of 2 FBI undercover recordings, not to speak to an FBI interview, not to speak with prior grand jury once or twice. I think he's been with a grand jury 4 times, Ms. Young said. I think that's right. It's impossible for any 12 people. I don't think you could get 12 lawyers to sit there and try to figure out, okay, I could use it for this, I can't use it for that. We have that volume of material. Ms. Young very smart, and she tried to address this point in her, because this is a huge problem for them. There's really no way to excise Brooks's name from Steve Lawson's statements without implicating Brooks. And Ms. Young said, we won't use the other person. So you change. Steve was in a work truck and someone told him they wanted Crystal Rogers gone. I don't even know how you could do that. So we go back to that, the very first point I made. In this case, there's no way that doesn't incriminate Brooks Houck. It's entirely different than my hypothetical, where I said Steve and I did the robbery, it was his idea and vice versa, where the entire world could be at play here. This whole case focuses on the allegation that he has murdered his significant other. Their entire connection, when I say they, Joey and Steve Lawson, the entire alleged connection between them and Brooks Houck is that they did some work for Brooks Houck. There is no way anyone can excise that statement and do anything but implicate Brooks Houck. And as his counsel in this case, there's no way we can not address that and assume that however cleverly this court tries to redact that statement, that somehow a court's limiting instruction is going to possibly protect him from a statement that connects these dots. And that's why this is, that's why this 20 hours of interviews occurs. Steve Lawson was the connection for the government's case. He was the one that was piecing this together for them. That's why they took, and I'm not criticizing, they're trying to make a case. That's why they took so much time with him and went to extraordinary promises to try if he did a statement that connects the dots. There's no way you can excise that, actually. The purpose of the 12:07 a.m. call was for Steve to tell another person the car had been moved. Go ahead and go to the next one.
So just, I
You just
think,
want to put the number in, right?
well, or yeah, or check contacts or however you do it to see who it is, yeah.
192-1390. Just call it. Oh, Steve Lawson.
So that's Brooks's interview with Detective Snow, Nelson County Sheriff's Office on July 8, 2015. It is impossible to excise that, knowing they're going to play that, and for it to incriminate anyone but Brooks Houck. There is no, it could be the whole world that he's talking about. There's only one person he's talking about, Brooks Houck. Next slide, please. And while I don't pretend to know exactly what the government's going to introduce in the case, I feel fairly certain that they will corroborate Mr. Houck's statement with phone records that show there was a 12:07 a.m. July 4th call between Steve Lawson and Brooks Houck. So we have done exactly what Taylor talks about in that case. We have now narrowed it down to there is only one person in the entire world that he is talking about, and it's Brooks Houck. Next slide. Again, the reason this was important, Steve and Joey were with another person on a drywall job when another person asked them to move Crystal's car. Again, we're down to exactly what Taylor's talking about. This isn't typical co-defendant case where it could be someone else, because that really is the standard. Can you do this in a way where you remove implication that is co-defendant? You're really supposed to be able to remove their very existence. Because otherwise, the confrontation clause of the United States is violated. There's no way, given that Steve and Joey Lawson were doing work for Brooks Houck on a drywall job at the time she disappeared. And Mr. Rogers' significant other at the time was Brooks Houck. There's no way to excise that without implicating him. It can't be done. Next slide. Another person told Steve to say that the 12:07 a.m. call was about rental property. Again, there's only one person that Steve Lawson talked to on the phone on 12:07 a.m. on July 4th, and that's Brooks Houck. Can't be taken out of there without implicating Brooks Houck. Another person promised Steve all the future drywalls jobs in exchange for moving Miss Rogers' car. Again, we're back to the same thing. That's who he worked for. That's where they talked about allegedly this moving the car and doing something to her. There's no way that doesn't implicate. It can't be done. Next slide, please. Once it becomes obvious that names have been pruned from the text, the choice of implied identity is narrow, and that's exactly what I'm talking about. We've narrowed in this case, these are the most important points from Steve Lawson's grand jury testimony in September after 20 hours of investigating and interrogating. There is no way to narrow that this could be anybody but Brooks Houck who's incriminating. We've not narrowed the identity. We've narrowed it down to the only person in the world that he's trying to incriminate is this man. The jury could immediately infer on the evidence for the redacted confession alone that the defendant in this case had likely named the co-defendants. It can't be anybody but Brooks he's talking about. So, while Ms. Young is correct, there is a preference for a joint trial. In this case, there can't be a joint trial and to get a fair trial. I really believe that there is a joint trial in this case, and there's a conviction. I believe everyone's going to be back here in 2 years. We can't, because there's no way to do this. And the state of the law is not, thou must have joint trials. That's not the law. The state of the law is, he's prejudiced, the court shall order separate trials. And this is a different scenario than the vast majority of cases where there is an ability to redact. It doesn't make that identity, the implied identity, extremely narrow, or in this case, only one. Next slide, please. Which is, again, why the Commonwealth said it in a different context about how could you possibly let us play Steve Lawson's 20 hours of interrogation for the purpose of showing a myopic focus on Brooks Houck while not incriminating Steve Lawson with the statements that he's made during this time. It's impossible, even if you gave a limiting instruction. But it's the exact same scenario in our circumstance. How could you possibly play Steve Lawson's grand jury statements, as the court has ruled are admissible against Steve Lawson, and not have that incriminate Brooks Houck, regardless of however clever the court may be in trying to excise his name, change it, put other person, put whatever, try to. It can't happen. It's going to incriminate him, which then forces us to try to explain how these statements came about. And here's where it gets particularly impossible from counsel standpoint. Let's say Steve Lawson decides he wants to waive his 410 protections that the court has found. And let's say the court joins this case. So what's going to happen is chances of Steve Lawson testifying, I think, are slim. Not my decision, but likely slim. So we would then be forced, knowing, and I don't think anyone can look at those quotes I just said objectively as a lawyer and say that those do directly incriminate Brooks Houck. But rather than getting to cross-examine Steve Lawson about how those statements develop, because he doesn't testify, we don't get to confront him. We are forced to try to cross-examine police detectives as to how these things developed. That's not what the Confrontation Clause gives us the right to do to protect him. That's what we'll have to do, and we'll do the best we can. But that is a direct violation of his Sixth Amendment rights. Because we can't, just as they said in a very similar but different context, no one can rely on that limiting instruction. It's impossible that jury's going to follow that. Because this isn't a 20-minute statement. This is 20 hours just with the Kentucky State Police in the summer of 2023, not to speak of all these other statements. Yes. Judge, you made a finding that all of the discussion of Steve Lawson's interviews after the 50-55 mark on June 8th, 2023 is inadmissible under order on July 3rd. You made a determination, which I think is really important from counsel's perspective. In this case, you determined that the recordings, which was Steve Lawson's interviews and his grand jury testimony, clearly establish that Lawson provided wildly inconsistent information about matters that are material. You found in that order, beyond a reasonable doubt, that he was untruthful. In fact, your order says that considering all the above, the court finds beyond a reasonable doubt that Lawson breached his immunity agreement with his untruthfulness about matters that are clearly material to the Commonwealth's investigation and prosecution. So, kind of flipping back before we get right into this 410 stuff. We have what I believe to be, from the government's perspective, they may say something different. This was the most important witness against Brooks Houck. This is a person that they spent days and hours upon hours interrogating, because I believe in their mind, completely disagree with this, but I believe in their mind, he connects dots for them. So in a joint trial, we would hear, pursuant to the court's ruling, 2 grand jury testimony, 2 grand jury statements by Mr. Lawson. We would hear jail calls that Mr. Lawson made to his mother and I believe maybe his wife or his ex-wife. All of which, as I hopefully meticulously laid out for you, are incredibly incriminating against Brooks, and it can only be against Brooks. And that person, so we would hear the sanitized version of this. Best government could do with someone who, the one thing I think we all agree on in this today is that he gave wildly inconsistent statements. He has been untruthful beyond a reasonable doubt. And we would be stuck with, because you had the ability, I've had the ability, governments had the ability, they were there to watch this whole train wreck unfold. But in a joint trial, the jury would hear the sanitized version. He wouldn't get to cross-examine. I have never in my nearly 30 years of practicing law had a court find beyond a reasonable doubt that a witness is untruthful. That's remarkable. I'm not allowed to ask you questions, but I venture to say that the court has never had to make that finding before. That's incredible. And yet, we would leave this jury with an incredibly false impression in a joint trial. In a joint trial, we have to be able to show a jury how Steve Lawson's statements to law enforcement developed. Prior to June 2023, Steve Lawson said the purpose of his 1207 July 4th call to Brooks Houck was he was trying to get an apartment. And he had been consistent with that for years. And what we've done before we start, please. So I didn't keep us here for literally after a week. We've edited clips. You'll see breaks in between them. You'll see the timestamp at the bottom. So obviously you have all the interviews. We've tendered them. You can go back and watch where it is, but we tried to clip the most important points. We've also, and I'm going to refer to some of this, we haven't put every promise made by the government in there. I'm going to reference some of that as we go. What we've tried to do on each one of these clips is show the court how we went from this 12:07 a.m. call was about renting an apartment to the ultimate incriminating statement that was made in September. But again, and then the number 2 exhibit that you have up there, Your Honor, is some of the other points in that slide where we went through what we believe the government's 6 important points of the September grand jury. We broke them down for you on that exhibit, so we didn't keep everyone here all day going clip by clip through each point. We try to pick what we think are the 2 most important points from the government's perspective from that September interview and did the clips.
Immediately after that, you called Brooks Houck.
Okay,
Okay. That's.
and I've told everybody that I told him I got the job done.
Hey.
I'm talking about the, whatever you call it, the skid stuff.
Stop for a second. Prior to this, Your Honor, as the court probably remembers, Steve Lawson was indicted for tampering with physical evidence. This is the day he was arrested. Prior to us getting into this, he's told, we can give you immunity, as the court is well aware. He's told the goal is not to send him or his son to prison. He's told we're not after you. You benefit us. And for brevity, and you can go back and watch it as it develops, and you probably have to do it in order for Steve Lawson. Before we even get here, he says, what the hell do you want me to say? What the hell do you want me to say? Now, how on earth can we defend Brooks Houck against these statements without being able to say he got arrested, he went into custody, and when he was told he could go home, the first thing he says is, what the hell do you want me to say? Because he literally would say anything to go home, and he did go home. Go ahead, Sandy.
I am telling you right now,
I'm listening to you right now,
We
sir.
may have something else going on here. Okay,
Okay.
what? That wasn't the conversation that you had with Brooks Houck.
What do you mean it wasn't the conversation?
That's not the conversation. Okay, did Joey ask you to call Brooks and tell him something?
Wait a minute, hold on now, let me think.
Yes.
Before.
I don't care because this is, listen.
Well, I'm listening to you, sir. Go
We
ahead.
know, like I said, we are giving your son the same thing we're giving you. Okay,
Okay, I'll listen to you.
listen.
The course of this interview, again, they're promising him immunity going home from jail that day. They're promising his son immunity to him. They have also arrested his wife at the time. They're telling him that she can go home. There is absent physical force. There is no more force and tactics that you can use than that. Now, that's just a fact. The jury can draw a conclusion about what the motivation was for the officers to do that, whether they believe they were doing the right thing to try to solve a crime, or whether they were under so much pressure that they felt they had to solve a crime. I'm not there. That's all on tape. And Brooks Houck didn't create that. That's how this stuff develops. And for him not to be able to get into that completely violates his due process, his confrontation clause. But to go back before we get to the next clip, none of this stuff should come into a trial of Brooks Houck. None of it. None of this stuff comes in if he is by himself. We're not talking about what Steve Lawson said in September. We're not talking about jail calls that Steve Lawson made. We're not talking about what the detectives are promising. We're not talking about the detectives putting words in his mouth, because it doesn't matter. But we are doing all of this in a joint trial because there's no way that we can let that September stuff come in. There's no way we can let those jail calls come in without diving in literally to all of it. And it's not, this is, and I want to point this out because you just saw it, and it took me a while watching this to really pick up on it. This isn't just going to have to be us trying to cross-examine one or both of these detectives about his changing stories. We got to play this because you can see in his face he doesn't know the answers. He is making this stuff up. And he's looking to them, and over time they are feeding him this stuff. And they catch themselves even. They know they're not supposed to do that. It's countless times that they say, we can't give you all the answers. Then they turn around and give him the answers. But you can see it in his face and his reactions. But next.
Real quick.
I'm looking right at you, sir.
Joey is out on the parkway by her car, where her car is.
Well,
found.
somewhere in that vicinity.
Right there. Okay, I mean, it's right there. Okay. Okay. He's out there.
Okay.
Calls you, you call him back. Calls you. You call the man who was last with her right then. Do you see? Okay, but this is the problem. And
I'm listening, sir. I promise you I'm listening.
So listen,
I'm listening.
we had you, brother. I got you. Okay.
Okay.
I'm not going to throw you under the bus.
Okay.
Got you. Okay.
I've done been told.
But this is common. Okay. Put yourself in my, this is common sense of what
Okay.
this phone call is.
Okay. I'm listening to
All
you.
right. We need the specifics and the truth. Okay. I mean, we have to have it. This is part of it.
Okay. Go ahead.
All right. All right.
I'm listening to you.
All right. This is part of it. It's part of your immunity, what you want. This is part of it. I want you to have a good life, man. I don't want to burn you. I don't want to expose you.
I promise you that's what you've told me, and I
But we
believe
have,
you.
okay, then we have to have the truth though.
I do believe you
Okay.
when you tell me that.
All right. So
I don't
we
think
have,
that you would tell me that if it wasn't a fact.
we got to have the truth about this conversation.
Honestly, I don't know if Joey did or not told me to call him. I don't know.
And Brooks ended up telling you,
In the course of this interview, and I didn't timestamp it for each one, for each particular clip in this June 8th interview. Steve Lawson says, I'm trying to figure out what you want me to say. The detective on the right is saying, this is your life. You and your wife's freedoms is in your hands. When he's answering questions, Lawson is saying things like, is that not what you all want to hear? Is that what you want to hear? I hope it is. I hope I made you happy. Does that make you happy? And on and on and on. I'm going to play the next clip.
to call in there that day, and it was clear that that was staged. Man,
He told me to call the next day, Crystal. Did he not tell me this?
so here we sit, you know? I mean,
Okay. I'm
Yes,
with you
sir.
so far.
so here we sit, so what? You have to be totally honest, man. You know what that conversation was? Like, look, I don't know if it was Joey's running a problem here. What it is that Joey's asked you to tell him or whatever you're in the middle of, but there has been a problem and we have to know what that conversation really is.
I'm telling you, the conversation went. Now you think I'm crazy, but I know this was some of the conversation that I
The
needed.
phone call was 13 seconds. just
Okay.
to keep you
Okay.
on track here.
That I needed to rent a home or an apartment, whatever the hell.
No,
you-
this has already been debunked. That didn't happen.
What do you mean that didn't happen?
That was not the
that,
conversation.
not that conversation. Not saying that conversation did.
I'm just saying, Jamie, I'm saying, I know good. and well
Not on
that
the
is.
phone at that time,
Not on that phone.
yes, that conversation. that I
The
had.
thing is this, again, we're in the fourth quarter right now.
I know, sir, I
and
understand
we're-
this, sir.
We are so
There
close.
may be someone, yes,
We are so close
Sir, I
to
understand.
you reaching the completion
The goal,
of your.
The
deal-
touchdown,
Of your
whatever
deal
you call
to
it.
walk out of this room today. We are close. But without this information, I'm telling you,
please,
it
please,
can't
please.
pass. That's what I'm telling
Well,
you.
y'all got, can y'all just give me a second,
Yes,
sir? Thank you, sir. I appreciate your patience. I'm gonna call it. I'm trying to think here exactly everything that I have said. What time was that again? Can you give me that, get the thing, please, sir?
It was
Thank you.
right after
Well,
Joey called you for a ride,
okay,
right after.
then I called Brooks right after
Yes.
that. I did, Joey didn't.
You did.
I did.
Yes. I know you're wrapped up in this and you don't want to be. I get that. You're gonna have to come off of this conversation and you still have your deal, Steve.
Sir, I know that. I mean, I trust you. I truly
You have to
trust you.
Understand that it's hinged upon this piece of information.
I just, y'all got to let me think for a minute, sir, exactly what was said and what wasn't said. Y'all can do that.
Yeah.
Thank you, sir. This is all the damn shit you ever brought me in my entire life.
Is it?
Sentiment or some kind of stuff.
I'll get somebody.
Shoot.
Sorry, man.
No, it ain't your fault. You didn't make the call,
I know you're
sir.
in a hard place, man.
I'm not really in no hard place, sir. You think I'm in a hard place, but I'm not. Because I'm gonna tell you right now, and I know I'm gonna get in trouble again when I say what I'm about to say, but I didn't give you my word.
Yes, sir.
My son put me in this effing mess, evidently. Because
We'll still.
now 2 and 2 means 4 to me for what happened at my house.
Mhm.
That somebody come out there and said, I got money for fixing up that damn house out there when it got drawn out of her 401k. Now shit, 2 and 2 is 4 to me.
Mhm.
I'm trying to. And what the hell, I'm not sure that's what was said or not. But I'm gonna tell you what I can recall is that burning up,
We'll start there.
burning up. Taylor said, I got him. Or the job is done. Now, they don't take long to say that, sir.
What did you mean by that?
Well, I'm pretty sure Jordan called. Now, don't quote me on that, but I'm thinking, like I said, it's been a long time.
We need to be very specific about this. This has played out in your mind a million times. We got.
No, actually, it hasn't.
Because you've been asked this before, you know what I'm saying? And you've had to come up with a reason. So this has been played out, like, I don't, look. All I want is the truth.
I'm thinking
Yes,
that's
sir.
exactly the way it was said.
What did that mean to you?
I don't know. When my son asked me to do something, most of the time I done it, just, well, I don't
So,
know. I don't
Joey-
know if y'all do what y'all's kids. or not.
Joey asked you to call Steve, or asked you to, I'm sorry. Jeez, okay,
I'm
Brooks.
pretty sure.
Joey asked you to call Brooks
Pretty sure of
and
it.
say what, the job is done?
Or I got it, or got it, whatever.
It's,
Whatever.
the gist of it is.
The
it's
gist.
complete.
Can we think, I mean, specifics is important here.
And I understand that,
And I know but what, to your knowledge,
to my knowledge.
what did you say in that 13-second conversation? And this is important, Steve,
Well, and not like I'm saying.
but not the gist of it. What
I'm
was,
thinking that's what was
so
said.
what did you say to Brooks?
That he said he's got it. I'm pretty sure that's what I said. When I said he, I was talking about Joe.
Joey.
Got what?
I did. That's what I was telling. That's what I was told to say. Best of my memory, that he's got this.
Now, where I think we're struggling, okay, and this is just a small piece, but we just need to clear it up. Just listen, just listen,
I'm
listen,
listening,
listen.
sir. I'm listening.
That conversation,
Okay.
all right, it's Joey calls you,
Yes, sir.
you don't answer, you call him, he
Yes,
doesn't
sir.
answer, he calls you back, and you guys have a conversation, okay?
Okay.
All right, and Joey then, what you're saying is Joey asked you,
Best of my memory.
okay,
Now, I'm saying that's the best of my memory, sir.
you remember to the best of your memory that Joey asked you to call Brooks Houck, is that correct?
When he said how, whatever.
Okay. And you know Brooks, right?
Well, I don't know him like that, but I know him, yes.
Okay. You know Brooks, okay. So you pick up the phone, you have your phone and you call Brooks.
Sorry.
And when Brooks answers the phone,
Okay.
to your best memory,
Okay.
what were the exact words that Joey asked you to say?
I'm telling you, I think that was it, that I've got the job done.
Okay. So the exact words are, he's got the job done. And then at that point, what do you remember Brooks saying?
I don't.
You get a phone call from Joey, you missed the phone call, it looks like you call him back.
Okay. Well, I didn't.
What does Joey say?
Come and get him. I told you that.
What else?
He told me where he was at.
Does he, at any other phone call or any other point, does he say something else to call somebody?
Not at that point in time, no.
When does he say to call? Because around that time, there's a call from you to Brooks.
That's after I get down there.
No,
What do you mean, no? Had to be, sir.
no,
It had to be.
no.
Now, see, now I'm confused because,
That's bullshit.
no, sir,
Yeah,
I'm
it is.
trying to
I
tell
got the
you.
fucking phone records, okay?
That's fine,
And
sir.
I got your phone moving, okay?
That's fine, sir.
But you
Go and sit
weren't
there,
down
sir.
there, you weren't down there when you called Brooks, okay? You
Well,
weren't.
where was I then? Because I'm trying to be a
I'm
smart
not, no,
ass.
man, I'm not, I can't give you answers. But here's
No,
what-
I'm not
here's what-
asking you
All right,
to,
here's
sir.
what I, listen to me, okay? Listen to me.
Go ahead, sir.
I can tell you timing, okay?
Okay, sir.
All right, I can tell you that Joey called you, there was a missed call.
Okay,
Then you end up talking to Joey, you get off the phone
Okay.
with Joey, you immediately call Brooks,
okay,
okay? Then at that point, you begin to move
okay.
and you go down the bluegrass,
Okay.
okay?
Well, maybe that was the first phone call. I'm sorry, I'm not for sure.
Yeah, I'm not, that's why I'm helping you, okay?
Thank you.
But you have, man, this is a significant event, okay?
Yes, sir.
You have played this through your mind thousands of times. Right.
Yes, sir.
So at this point, you've already.
So now in this one interview, we've gone from, this was about an apartment, then we've gone to, it was a job done. Then we've gone to cars broken down. In between that, as you go back and look, you'll see constant This is your life. This is your life. You gotta get your deal. We can send you home tonight. They did send you home tonight. Constantly throughout this thing. And you'll see, and we try to point out different clips, continued suggesting about what the story was gonna be. Now, one of the important points I want you to recall from that last clip, because we get into some more, is where this 1207 call was made is going to be part of the government's argument. We don't believe this call had anything to do with moving Crystal Rogers' farm. That said, when he makes that statement at first, he thinks the call's made. By this time, he's gotten to the point where he's saying, I went to her. And he's saying the call happened at the call. Well, that's not consistent with what I believe the government is going to present in this case. They're going to argue that that call was made in Bardstown. Watch from that clip where he's corrected that your phone call, we believe, was made in Bardstown, not out on the Bluegrass Parkway. Watch me get to the next sentence.
You called Brooks, right? Before you left the house, you called Brooks.
Yes.
Yeah, I guess.
Why did you call Brooks?
Yes.
Steve, be honest.
Well, I'm trying to be honest here, sir. I'm trying to think.
Why did you
of
call
the
Brooks?
event.
Why did you call Brooks?
Tell him I was gonna pick up Joey, I guess.
No, not a guess. Why did you call
That's
Brooks?
why. Okay, did that,
All right.
was that,
So why would you call Brooks
To tell him you were gonna pick up Joey.
to come here and pick up Joey? Why would you call Brooks to tell him?
Be honest, man.
Just be honest, man.
'cause I
I'm giving you-
know, I'm sitting there trying to tell
All
you,
right,
sir.
okay.
Thank you. Now, like you said, why did I call Brooks?
Yeah.
I called Brooks because I knew, and I knew. No, don't agree. Look,
All right, come
shake
on,
your
say
head.
it. Say it.
They was trying to involve me in this mess. Of course, you already know that.
I do know that.
Okay, you know
And
that.
but we need you to tell us how they were involving you in this mess. That's what's important.
Okay, lots like the car deal. Here we go.
All right.
I knew my son was pretty much gonna take the bus car, but I thought he was gonna steal it, and that's fact.
Okay.
You know, I called Brooks, the job was done, you know, I'm not for sure if I called Brooks right after or not. I'm not for sure. That, you know, if the job is done or what the hell else ever. I'm not for sure. And I'm just to be honest with you, for that time I was a nervous motherfucking wreck. How's that? Does that make any sense to y'all? Tell Brooks it's done. I've done just that. Maybe he had to tell Brooks that it's done to make it so, or what the hell ever. That one I truly ain't got no answer for, and I'm sorry.
Let's talk about that phone call real quick.
Okay, go ahead.
You called Brooks.
Okay,
All right. What are the exact words that you tell Brooks on that phone call?
it just what I just told you. The job is done.
Okay. And then what is Brooks' response?
I'm thinking it was okay.
No, nothing other than.
No, not fuck you, not none of that crapola. But I mean, I don't know if that's helpful to you or not. I don't know.
You just need to think and come clean. Do you need a smoke break?
We can smoke if you want to. I mean, that's fine. Yeah, that's fine. Yeah, that's fine. But I'm
Because
telling
you need
you,
to really think here. Okay, I want you to jog your memory and think. I don't want, like I said, I want total honesty and I
and
don't
I'm
want.
trying to be honest. I don't know what's
Wow.
wrong with the woman.
Okay. All right.
I mean, if I lived with a woman, I wouldn't be ashamed to tell you I lived with a woman. I mean, that would be stupid on my part to
You want
be.
to take him out and smoke real quick? I gotta ask some questions.
Throughout instead of multiple unreported smoke breaks. They take a couple in June. And you'll even see them get into one of these, they're clearly talking about.
So then at some point right around there, you call Brooks.
I called Brooks. Maybe I did. I mean, I'm not gonna say, and maybe I told him I got the car moved. I got, it's done.
Okay.
I mean, I'm not gonna say I did or didn't because I don't remember calling him, but if I did call him, I'm gonna tell you that's exactly what I'd have told you. Now, I know at one time I called him and I told you that I called him.
What did you tell him?
That's when I called him at the police station.
To talk about that conversation that evening.
And I told him, I said, in the department, he's like, well, wait a minute, or whatever he said it. I don't know exactly how he said it.
And that conversation was staged.
I went to there, we go. Yeah, we all know that. I've done it, or admitted to that, or whatever you want to call it there.
Okay. All right. So at some point you called Brooks on your way to say what?
I don't remember, I told him that the job is done, the vehicle broke down, I don't know. But that's gonna be my guess on either one of
Okay. So you were just talking about
Yeah.
what that is.
them. What transpired, how's that, is that
And
word?
then later, on, when do you call Brooks that evening?
No.
Was it shortly after? Was it all while you're on the parkway or right when you all get home? Within that time frame?
Well, I mean, I don't know, might have been going up the parkway, could have been as soon as I was getting off the parkway. I mean, I can't say exactly when I picked up the phone and talked to somebody, I'm sorry.
And that's what needs to happen. That's all we can
It
ask.
should be
of you.
noted
There-
that outside that we weren't really talking about
Yeah.
these specifics, we were talking about not omitting stuff.
I'm not for sure exactly when the phone call took place. I'm not gonna say on the BG, off the BG, I'm not gonna say. Cause I'd be lying either direction. Cars moved. Job done, well, however you wanna phrase it,
You call who?
that's Brooks.
But you're out there to call him or who?
I think Joy asked me to prove
You
it,
don't know.
but I mean, either way, he got a call, regardless whether it was me or Joy, whoever they said do it, he got the damn call.
You want to continue on and take a smoke break?
Smoke, you know, smoke.
That's not me, sorry.
Let's go.
Yeah,
Let's go. Well, out there, we were kind of talking about the phone conversation,
Okay.
going over like, we,
yes. And
just in a chronological order, we were trying to do things,
Yes.
so we kind of skipped that, we need to get into that.
Now I'm gonna go to that, and I know I'm gonna
Okay,
take,
so
but you're
about
in here.
shortly after midnight,
Okay,
okay?
shortly after midnight, I
Make a
phone call.
to Brooks. yeah.
Correct. And the job was done.
Okay.
I just got a okay or whatever, I'm not for sure exactly, That was pretty much the end of that conversation,
Throughout these interviews, talk some about promises that were made by Steve Lawson. Seen a lot of the suggestions about what we needed to say. There are countless times that Steve Lawson in these interviews said, for example, I put myself on your side of the table. I want to be on your team more than you will ever know. you will help me out, we will get it right. Boys, I want to be on y'all's team. And on and on and on it goes. At one point, one of the detectives in September even says, we're giving you more than we should. So what this trial becomes, if we do it together, it becomes about hours and hours and hours of Steve Lawson and his inconsistent statements. It becomes hours and hours and hours of us explaining the promises that were made that led him to change his stories. It becomes hours and hours and hours of us pointing out all of the times that Lawson said things like, does that help you? Is that what you want to hear? I want to be on your team. But we move that back to the very beginning is, none of this is admissible against Brooks Houck. None of it. And it's not admissible against Brooks Houck unless Steve Lawson elects to testify. This case completely changed when they indicted him in December. That's their business. They get to decide who they want to indict. But what happens is, as you can see the progression of these interviews, is he gives them what they want to hear, and they want to hear more because they're going back with other witnesses. Promises are made. He continues to change his stories. And ultimately, in September, as the court is well aware, Brooks is indicted, Joey Lawson's indicted, Steve Lawson is not indicted. Steve Lawson is not indicted until December, when apparently he essentially makes representations about where they might be able to locate this Rogers body. And that turns into a major event, major dig, and of course, it's over. And nothing was found. But as the court has said, he is untruthful beyond a reasonable doubt. There's no way that any defense of Brooks Houck can proceed without getting into all of that. And coming back to one of the points I said, is I think it's really powerful of you. If someone points it out to you, watch his reactions during these times. He's making this up. He is genuinely surprised. You can see him taking time to think and trying to make sure he is saying what he needs to say to go home. For the government, they have a different spin to that. I'm sure they would stand up and they would say, oh, you know, people lie and it takes a long time to get the truth out of people. But if you watch that, an objective person is going to believe he's making this up. And to defend him, you're gonna have to show that. It's not just the typical cross-examination. Did you say the car was red today? Yes, but last time you said it was purple? No. That really is powerful. Go ahead if you can go to the next one. Second point we wanted to illustrate in the in-court presentation portion of this, and again, the other points are in the exhibit we gave you, was did Brooks Houck, in September of 2023, Brooks Houck, according to Steve Lawson, says, I want Miss Rogers gone. Going back to 2020, an FBI confidential informant secretly taped Steve Lawson. Lawson says in that secret recording, I swear, I don't think Brooks had anything to do with it. In a second recording of this confidential informant in 2020, Steve Lawson said, I don't think Brooks had anything to do with it.
Can we smoke cigarettes before we even start this? Go out here, then whatever you gotta tell me, you can tell me out there. Is that fair enough?
Yeah.
Fair enough, sir. Thank you.
Hey.
Yeah, Steve wants to smoke a cigarette
Well, we already started. That's all right.
There was a point when you got out of his truck. Okay? And let me,
Are you sure about this?
yes, sure. Okay,
I
I'm trying to help.
I know you're trying to help, but I don't remember getting out to the man's car.
Okay. There's
And
a
that's a
point,
fact.
Stacy asked you what you were talking to Brooks about.
I don't even remember Stacy being there.
Okay, she asked you what you were talking to Brooks about. Okay.
Okay.
She says, you say, I have to take care of a woman with 5 kids who's hooked on meth. Okay, and Brooks might have let you to believe to kind of minimize, you know what I'm saying, what's going on
I'm
here.
trying to.
You know what I'm saying? Because if you think, like, okay, I'm helping because the kids are better
Oh, yeah,
off.
I understand what you're.
Do you know what I'm
What
saying?
you're going toward there. Yeah, but if somebody's on dope, that kids are better off being without such a.
Yeah, and so
I understand
you're-
what
you're-
saying.
Helping with just the carport, okay?
Yeah.
But I want to make sure that we're on here and you're telling the complete truth.
Well, I'm trying to think because
This is important, very important. Because it wasn't Red that we were talking about. Red has 2 kids. This is a woman with 5 kids, and this was reported immediately. And like I said, unfortunately, I can't go into detail.
I don't want to ask you
Okay.
to, you know, I didn't.
But this,
I don't know, y'all think.
This is where you're at the crossroads.
you're at the crowd right now.
This is where you're gonna have to come clean with this.
Well, I'm trying to think if I said that or not. You don't want me to say I said it.
No,
If I
correct.
didn't.
Correct.
I want you to tell the truth.
But I don't want, I want you.
You don't want me to minimize it, but you don't want to say,
Correct.
yeah, I said this if I didn't say it
Correct.
neither.
That's right. You're exactly right. Okay.
Because then that's just.
Correct, but remember.
Yes.
Remember, we know more than what we,
5%.
this has to be.
Not possible to defend this case without showing that clip. You could see on his face, he doesn't have any idea what they're talking about. And they can make a different argument, but I believe any objective person watching that, he clearly has no idea what they're talking about. And then they know better than this. They say it in their interviews. We're not supposed to feed you stuff. They know better than this. My guess is there's so much pressure to solve the case. They want to solve it so bad. In their mind, they're doing the right thing. But what they did is not right. And they're telling him what he's supposed to say. And you can see he's at him like, there's no way to defend Brooks Houck without showing that clip. And again, we're showing the clip to defend him from something that's not even supposed to be admitted against him. There's no way that's fair. That is beyond unduly prejudicial. Go ahead, please.
Straight up between all of us. I mean, you got to come totally clean.
I'm just trying to remember if I
We're
did
trying
say
to
that or
save
not.
your ass.
And maybe you remember this conversation going in a different location, but
That is where me and you were on the same page there.
so where do you remember this conversation happening?
The bar.
With who? Brooks?
No, I've never seen Brooks at no bar.
No.
I never even knew that he went.
What I'm saying is, Steve, at some point, you were with Brooks. And Stacy approached you after a conversation that you had with Brooks and asked you what that conversation was about.
Okay, I'm with you so
Your
far.
answer was, I've got to take care of a woman who's addicted to meth and has 5 kids.
I'll be honest.
That's what I'm telling you. I think that is said at the bar. I swear I do.
Okay.
I still.
Where did the conversation between you and Brooks take place at? Where this was mentioned? What, the reason here's what I'm saying.
Okay.
Is you said this, okay?
Okay.
Here's what I'm saying, but where did this conversation, where did Brooks tell you this at?
The only place that his truck would have been that I would ever been would have been at that house right
That
here.
house? Okay.
There's a house here, the lot here, and they were building this house up here.
We have to quit talking in the only hypotheticals here.
No, I'm not talking like that. He asked me where the truck was. The truck was here.
So you were in the truck with Brooks there?
That's the only place I could have been. That's the only place the truck was.
So what was this conversation? Talk to us, tell us.
I don't really, well, that's what y'all don't understand.
Okay, do you remember telling that? Do you remember saying that to someone?
I'm still saying I said that at the bar.
Okay, all right. And what? So was this right before, it had to be before then? Was this like the night before, the day of? What?
I'm gonna say the night before.
The night before?
This is what I'm gonna say.
Okay, okay. All right. So you're saying this the night before? Well, don't say, I mean, what do you recall?
And that's what I'm trying to say. When y'all said that I got out of the vehicle and said something like that, I never recall ever saying anything like that.
Okay, when did you say it?
And I could have swore it was at the bar.
Okay, so did she ask you there? What you all were talking about while you were on the job site, or how did this go?
Trying to think back, because that's been a long time ago. And I still don't remember her being at the bar though. But somebody had asked me, well, who the hell asked me where I was going, or what I was doing, or what the hell I was talking about. I can't remember who the hell it was. But it seemed like to me, and this may sound stupid to y'all, but I'm thinking it was a man.
Okay,
I don't think it was a woman.
okay.
I swear I don't.
Yeah, this is a very important event. You have to come to here.
I'm still thinking, oh, I swear to God.
Okay. From the more stuff you say, the more truth you give, the more
Freedom.
freedom, yes.
Well, I'm gonna-
Yes, correct. The more truth and totally wiping the slate clean, the more your slate's wiped clean. And this is a gift like I ain't never
I
seen.
understand it, but
All
I
right.
can't remember it. I had said that Charlie, or if I had said it, but like I said, Charlie was there at that one time. Or somebody else walked up on me.
Do you remember saying it?
Yes, I just told you that, yes, but I don't remember.
All right, and were you talking about Crystal? Is that where you got that from Brooks?
Yes.
Okay.
Let me say this, that's why you don't seem like y'all leading me through nothing here.
Okay.
That is what I did say.
Okay.
I said I gotta take care of a woman or maybe a young lady, I don't know how I phrased it. That's got 5 children. I said it.
Because the person that said it, okay, says that in their statement that they understood that that person was going to be dead and that you were doing the world a favor because they were hooked on meth. Did Brooks ever mention the fact that she was hooked on meth?
Not that I could ever recall, that he ever said that she was hooked on.
What was your conversation with Brooks? What was it?
Yes.
What prompted you to make this statement to someone else based upon your conversation with Brooks? What was that conversation?
Well, let me think before I spout my mouth off and say something wrong. And I remember it's there, the truck was up here. Maybe Joy was running about that off from up here. No, yeah, maybe.
Who was running the Bobcat?
I think Joy was at that time, maybe.
Who else?
And just wouldn't nobody run that with me and him, sir, nobody. If somebody else run it, I never know
Okay.
anything about it.
Okay, okay.
Like I said, Brooks asked us to move the car. I'm thinking that was all the same day. I don't quote me on that. But I'm thinking it was.
So, so that was an interesting clip. You look at him when they ask about who was running the Bobcat, he immediately answers, because it's telling the truth. Rest of it, you can see was, here's what they're trying to do. And again, their motivation, I don't think. But what happens is, in October 2015, a lady goes to the police department and says that Steve Lawson got out of Brooks Houck's truck and said he had to take care of 5 kids and that effect. Wasn't right away. But that's what she says. Now, mind you, there's absolutely no evidence that I've seen in the bazillion pages of discovery that ever indicated this Miss Rogers was on methamphetamine. None whatsoever. They just sort of gloss over that. What they're trying to do is they're trying to get him to corroborate that statement. And as you can see from the very first clip, we'll go through the rest, he has no idea what they're talking about. None whatsoever. And you see they feed the exact thing that this lady says in this October 2015 statement to him. And you see the progression of how ultimately we get to the grand jury where it looks perfect. It fits like a glove.
You had a conversation with Brooks.
Okay, let me let you.
By your own admission, you've had a conversation with
Okay.
Brooks. Okay. From that conversation, you felt the need to tell someone that you had to take care of a woman addicted to meth that had 5 kids. Okay. But listen, stop. Okay. This is where you're at a crossroads. Okay. This is the stuff that's hard for you to hear come out of your own mouth. I get it. Okay. But listen, you can't tell me. I'm not calling you a liar or nothing. Okay. But you can't tell me that you remember telling somebody about the conversation, but yet you don't remember the conversation. It doesn't work for me. Okay.
Well,
So what I'm saying is, if you need to think whatever it is, that's fine.
that's
But
cool.
we need the details of this conversation. Okay. This is important.
Yeah.
What I'm asking you is, what was the conversation
Between
you and Brooks?
Yes.
What was it?
Well, I don't, this is the fact. I don't ever remember him saying nothing about me. Maybe I throw that in there. I don't know. But, no, that's a fact.
So what would tell us about this conversation? What was the conversation? You were there. You know, what was the conversation?
Well, like I said, we were sitting in the truck here. We got to that point. If you give me just a second there, I told you I was gonna think, because I don't want to tell you something that ain't so. Then you be pissed off.
Correct. Just like it is,
And what was it?
all the way,
Well, that's one thing.
1000% honest. You've got to be.
And that's what I'm
Wipe
saying.
your
I
plate.
need to see exactly how he said whatever, however he said whatever she said. We'll put me with.
Obviously, the problem with this is court knows. The detectives in their minds have decided what they believe the truth is. The whole time this is going on, through all these interviews, they are continually telling him, this is your life. Go to prison for the rest of your life. You're gonna go to prison for 20 years. Don't screw your deal up. We promise the deal of a lifetime. Never seen anybody get a deal like this. And then they'll come back over and over and over again, and they'll say, this is it. This is really important. We gotta have this. We gotta have this. And ultimately, he'll get where they want to go.
I think his exact word was, exact. Well, I just like her gone. Well, to me, gone means gone.
Mhm.
That don't mean, I'm gonna divorce you and you're gonna go your way and I'm gonna go my way. Gone means gone.
Yes.
And I'm pretty sure it means the same thing to you. Correct?
Are you saying dead?
He didn't say dead, he said gone.
But is that what you're?
That's what I'm,
We're just having a conversation.
that's what I'm
Okay,
insinuating.
let's just,
You know
let's
what
just
he's
talk.
Yeah,
Let's quit, let's just talk.
Yeah, that's what I'm saying. That's,
He
to
wants
me,
her out of it.
out of the picture.
Correct.
That's the best word I can use for it. And I'm like, well, I don't really know how to help you with that. I ain't got those kind of connections. I ain't got that kind of reach. Hell, y'all know I don't.
Okay, so I'm gonna stop you there.
Yeah, go ahead.
What did he ask of you?
Basically, again, could you move a car if I need you to move a car? So that means, and this is my opinion, it ain't what he said, this is just my opinion, that basically he was, I don't know if he, except personally, is going to do something and he needs the vehicle just move.
Well, I mean, you know what the hell's going on.
Yeah, but that's what I'm
Yeah.
saying,
Okay.
it,
But you just said you didn't have that kind of reach or have that kind of connections. What would prompt you to say that?
well,
What did he say that would prompt you to think or say that you don't have that kind of reach?
well, when you tell me you want her gone, I mean, why are you telling me this? Why are you telling me? Because I ain't got that kind of reach to make it happen. Or maybe he was just, how do I say it? Maybe he thought I'd trust me. Or maybe he thought maybe this is a good man to set up for the whole fucking deal.
Correct.
Y'all evidently got something on y'all's mind that I was out there doing something.
No,
different.
no. There's something very important here, okay? And we're missing some steps from the car to there.
And I don't,
That is major and you're
understand
going
what-
around and you're missing
I
very,
don't
listen,
know what
listen.
I'm missing is what I'm trying to tell you. What are you
Stop.
talking about?
Well, if you stop cutting me off, I'll be able to tell you,
I apologize.
you know?
Can we go smoke while
Yeah,
you
come on, let's go. Take a break.
And I got a stupid question. That's not a stupid question. Y'all may not be,
No, no
y'all-
questions in here are stupid
y'all
because
may
this is
not-
the rest of your life.
y'all may not be able to even do it. I just want friggin' Tylenol for my damn hand. If y'all got a
Okay.
Tylenol.
Just one?
We'll get,
And I don't,
somebody here's probably.
yes, I can get you just one, all by one pill. That mother is struggling like a fucking toothache.
Where's he with her?
I think what we need, I think we gotta clear it all up. We've been all over the place. Let's go.
Let's go. Just like I told you outside there, been going mosey. Joey been working for Mr. Brooks. Joey kind of remember when and how, where, what time it was. Said, Daddy, I said, what? He said, Brooks got some work needs us to do. I said, what does he got to do? He needs some Bobcat work. I said, well, we got it. I said, but we'll have to go see him tomorrow. So we ride out there and me and Joey did. Actually, I take Joey to work is what I was doing. Get out there, he said, well, I need this lot, this lot, this lot, that lot, I need them scraped up. Okay, good enough. Give him a price. And went from there. I don't remember if it was that day or the next day. You told me 2 to 3 days, I could say that. Boy spoke up first. Yes, we'll help you move a car. He said, Daddy, we might have to go move a car. Okay, then we'll go move a car. That's what we'll do. You know, just tell me what we're doing. We're gonna move a car. I don't know where Joey went from that point. I don't know if he's up here or if he's down there. I don't give a shit where he's at. Brooks's truck's always parked up here at this house, but by this time, most time that's where they parked, wherever he was framing at. Have a conversation with him. You know, I don't like the bitch. We don't get along. He never called her a whore, but that's what I'm gonna use. Okay, I want her gone. Plain and simple, that's what he said. I want her gone. Okay, you want her gone. First, like I said, I did say straight up and down, I would help you with the automobile. And I did tell him that. He said, well, I'm gonna use the word guide. And me in a direction. I might be getting something like that, but well, is that a good way to phrase it? I mean, you keep
He
looking at
wants
it.
you to guide him in a direction to get,
Yeah, I get,
Honda's not good.
yeah, that's what I'm gonna say. Let me say, well, exactly how did it phrase? I want to try to get it perfect here. Like I said, I seen the truck and I was just walking up here and said, hey man, I need to talk to you. I said, well, okay, what's going on? I'm pretty sure he said sit down. Well, I'm not for sure, but I think so. I'm like, yeah, what do you need? He said, you know, me and Crystal we're not getting along, or we've had words, or whatever he called it there. I mean, it's all the same thing. They're not getting along. Well, you know, my first end of the thing, you know, I hate that you and your old lady ain't getting along. Because I don't get along with my old lady, so I wish somebody'd say that to me. Well, that's not what I mean. I'm like, well, what do you mean? Well, basically, I hate her. How's that? I'm like, okay, well, that's not a good thing. He said, I'd like to see her. I'd like to see her go. I think that's the way it's phrased. I'd like to see her go. I think that's exactly where it's phrased. You'd like to see her gone. He's, you know, like, gone. When you say, and I'm pretty sure he done, I think he done had gone. To me, in that instant, that's the way I interpret it, just like you just said, that he wants her deceased, dead, however you want to say it there.
Going back to the first, obviously, we put some of this in our section of the exam. If we go back to the beginning of the points you covered, there is no way you excise that out without an incriminating Brooks Houck, because they're going to have the witness who came forward in October who says she saw Steve Lawson get out of that vehicle, and that's why that was so important to them to try to corroborate that. And you see the progression all the way through. So in a joint trial, set aside the 410 issues. That stuff directly implicates Brooks Houck, and he is narrowed to the only person. So this decision shouldn't hinge on what Joey and Steve Lawson choose to do with their 410 privileges. We are a case where we are unduly prejudiced by being in the same trial with these people. That's why I wanted to show all these clips from just these 2 points. You have a multitude of other points there. And you go through and listen, as I said, countless times where it kind of the goalposts will change. Part of that June 8th interview, you know, you're almost there. You're going to go home. He doesn't go home. And then to get to the next point, we gotta get the next point right, we gotta get to the next point right, we gotta get to the next point right. Try to fit this all together. And I can't say it enough, none of this is admissible against Brooks. So all of this, this is a joint trial, all of this stuff is dumped into this trial under some sort of theory that's somehow a limiting instruction, saying, don't consider 2 full days of trial, 3 full days of trial, 1 full day of trial, ever how long it takes, probably 2 full days of trial. Don't consider any of that as it relates to Brooks, but that's all we're talking about. That, there's no way that's not unduly prejudicial. It's also, we would have to, under due process, under 410, be allowed to get into that in a joint trial. And then there's the question of Joey Lawson. We've spent most of our briefs, most of the government's briefs, our discussions have been about Steve Lawson. In their brief, Joey Lawson, the government says they concede that his statements made to the FBI and his statements made to KSP up to maybe August of 2023 are protected by 410. But there is a statement that they specifically mention in their brief that is not protected by 410, which certainly incriminating things are made. We don't know what their position is going to be. Now, if anything comes in from Joey Lawson from that August 2023, or if court were to join these cases, Steve Lawson's statements are coming in. How can we not be allowed to play this, which you have a protection?
All right. You all are in 2 separate cars at this time. You rode there together. You're in 2 separate cars. Okay? One of them is the car Steve's operating, and one of them is Crystal Rogers' car. Okay? And I don't want you to think that this makes guilt or anything like that, okay? I really am trying to help. I hope you can see this now.
Yeah.
Okay, and I hope you can see that I'm not a BSer. Okay, all right. Then Steve, you call Steve a little bit. Steve goes and gets his phone back from Demery, okay? Him and Tammy are doing him and Tammy thing because they're arguing. She thinks he's cheating. There's shit going on with the Chrysler 300. Same shit that always goes on in Steve's life at that time. Okay? So the same shit that's going on at Steve. So Steve has to go get his phone. Once it happens a little bit later, call Steve. Okay? And I don't know who did what or what would happen, okay, or who asked who to do what, or what stupid situations people get into. And I'm not concerned because I'm not after you, okay? And I'm not concerned because I'm not after Steve, okay? All right? So let's get that straight right now, okay? So at that time, you call Steve. Why ever? Steve doesn't answer. You call Tammy. Steve then calls you back. Steve calls Brooks then. Tells him the job's done. Okay? Steve goes on the parkway at that point. Okay? Steve goes to the turnaround. It's raining. He goes to the turnaround.
Which turn?
Right past where her car was parked on the parkway.
Exactly where it was.
14-mile marker. It's going toward Hardin County from Bardstown. Okay? Steve.
Like before the New Haven exit.
Yes.
After.
Yes, it's going toward Hardin County. Okay? So Steve goes past her car. He comes back up the turnaround. Okay? He goes back up the turnaround. He parks. Going back toward Bardstown, parks on that side. Her car's on the other side going toward Hardin County. Okay? Her car's on the other side going toward Hardin County.
We didn't put it all on there. You have, of course, the entire interview. You literally just tells them what to say. You can hear Joey Lawson say, asking questions to make sure you're getting it right. You'll hear in this interview, Joey Lawson saying things to the detective like, what do you need? Do you need me to say Steve did it? I don't know what Steve did, but if you need me to say it, that's fine. I'll take your offer. I'm not trying to go to jail or prison. What am I supposed to tell you? That Steve moved the car? Question. I just want to tell you all what you want to hear. In this August 28th interview, the one that the government doesn't concede is inadmissible, the detective literally says on a recording, whether you killed her or not wouldn't be our concern. Again, as it relates to 410, you don't know what their positions are. But we're clearly allowed, if anything he says comes in, to get into that. But more importantly, and this is where it all dovetails, and is it back to the point of we shouldn't even have to get to the 410 argument here. If Steve Lawson's, let's say Steve Lawson waives his 410 privilege pursuant to the court's rule. Let's say Joey Lawson doesn't. How on earth could we not get that in? As it relates to Brooks Houck's due process rights to show how law enforcement coach these statements. You can't coach someone more than that. He literally starts with the government's theory and ends with the government's theory. And the only breaks in there is Joey Lawson asking a couple of questions to make sure he's going to get it right when he regurgitates it. It's incredible. I wouldn't believe it if it wasn't on the tape. That's what happened. At one point on that tape, at that interview, you could hear the detective say, I haven't fed him that yet, in a side conversation relating to a different fact. Go back and listen to it. If there's ever a case that shouldn't be joined, it's this one. Cross-examination directed toward revealing possible biases, prejudices, or alternative motives is a proper and important function of the constitutionally protected right to cross-examination. Carry 104 says everyone has the right. The party to introduce before the jury evidence relevant to the later credibility, including evidence of bias, interest, or prejudice. Everything in these interviews, from the promises of immunity to the this is your life, this is your, we're giving the same offer to your son, the same offer to your dad, we're going to be offered to wife, you can go home tonight if you just got to say this. All of that is, it's by Davis versus Alaska was just about the fact that you could introduce the fact someone was on probation because they might want to curry favor with the government. I mean, that's somewhat speculative because there's no direct promise. And here are direct promises over and over and over again. So there's the carrot, and then right after it, the detectives there with the stamp. You're going to go to prison for 20 years. You're going to go the rest of your life. Your family's going to go to prison. All of this is admissible to show their interest and bias, except again, to come back to the point, none of this is admissible against Brooks Houck. Because we're just gonna operate under this fantasy that simply saying, don't consider any of this against Brooks. It's not admissible against him, is somehow going to protect his confrontation clause rights. It is a fantasy. Which brings us to the third point. KRE 403, a joint trial confuses issues about who the evidence is admissible against. It needlessly lengthens Brooks' trial and denies him due process. Just think about, I've been talking maybe an hour and a half, and I have just given you short clips from different parts of these interviews. You have a document that breaks through some of these clips on some of these other points, because I didn't want to take up your entire day and government's entire day. We're talking about 20 hours over days. And then if you had Joey, you're talking about, probably 30 hours of this stuff. Just to demonstrate their interest and bias, to combat the fact that we all know it's a fantasy that people aren't going to use that against Brooks Houck. And we have to explain how these things come about. That, if there's ever a confusion of the issues, that's it. At the end of the day, due process mandates a separate trial, and it really shouldn't rely on whether Steve Lawson wants to waive his evidentiary privileges, or Joey Lawson wants to waive their evidentiary privileges, or one or the other. And when one says yes, one says no, what happens if one of them changes their defense strategy later, gets new lawyers? Who knows? We don't even need to get there. Because this is a case that is, and I believe I have firmly demonstrated that it is unduly prejudicial to Brooks Houck to join these people regardless of this 410 issue. But the 410 issue guarantees this case cannot be tried together. Thank you, sir.
Ms. Young.
Judge, I thought that once they explained their position in this, that I would understand what they were trying to argue, and right now, it's about as clear as mud to me. I have already told the court, and I explained before we started, that we have no intention of using grand jury testimony from Steve Lawson against Brooks Houck. I can't use things that Steve said about Brooks against Brooks. That's testimonial evidence. And I know what Samia says, but I'm not going to try to redact that in order to get that in a joint trial. So that part makes no sense to me. What else makes no sense to me is the 410 part. That makes no sense at all. Joint trial, I can't use it at all. Doesn't come in at all. Can't use it in any way, shape, or form. Guess what? In a separate trial, I can't use it either because it's testimonial evidence. How would I utilize that? So I don't understand this argument that I've got to be able to show how that developed when it's not even coming in a trial. It doesn't matter what kind of trial we have. It's not coming in unless they want to waive it. And if they waive their privilege under 410, then it's Katie bar the door and we can all talk about everything. We can get into every bit of it. And they can waive it standing up in an opening and say, hey, my client was forced to go and say this or had to say this or whatever they want to bring up. And we're all there and we can get into it. But it makes no sense to me why you need a separate trial in order to explain statements that are not coming in against your client. They simply are not going to be utilized. So I guess I don't understand that. I also would like to clarify that on the August 22nd interview and the September 12th interview, Steve Lawson's attorney was present. And part of those big long breaks you see is Steve consulting with his attorney. So I assume if we're gonna talk about all the breaks and smoke breaks and stuff, we'll have to bring in other witnesses and talk about what was going on and you know, that Mr. Lavitz consulting with his client during part of this, and that's why these breaks go on forever. The June breaks are taped because Lawson's in custody. So they taped everything. But after that, he's free to come and go as he pleases. If he wants to go out in the parking lot and smoke a cigarette, that's his choice. One thing I do think that we need to address while we're here, well, there's more than that, but one thing that I do think we need to address is this idea that every statement that Steve and Joseph Lawson ever made cannot come in a separate trial against Brooks Houck. Out of court statements play by a whole different set of rules than testimonial statements. They are not the same as testimonial statements, and these two have made plenty of out of court statements that incriminate them. That's part of the reason Steve Lawson's getting interviewed that day, is because he's already told people, I got paid $50,000 to move Christopher Rogers' car. He's already in it. So those statements can come in a separate trial, and I'm gonna let, or in a joint trial. It does not matter, because those statements, which are made by a co-conspirator, or they're either admitting their own penal conduct, it's a statement against interest, or they talk about a statement in furtherance of conspiracy, as long as it is something that meets a hearsay exception, is going to come in. And if we weren't really thinking we were going to talk about this today, but I think we've gotten there. So if Mr. Lasowski could address that for just a minute, because it goes to the phone calls that they're addressing later. The phone calls at the jail that Steve Lawson makes later on that are not in custody.
I'll be brief, Judge. I'm just following up on what Ms. Young talked about. As the court knows, for recent many years, you've been a judge, prosecutor yourself, and trials and procedure unit who I've worked with have tried many cases as well. The rules of evidence and the law guides every trial. Their arguments are made, issues are presented to the court, decisions are made about what evidence can come in, what evidence can't come in, either whole or part. There's evidence in this case under 804B3, and it's a recent development. We used it in federal courts quite a bit, but it was not used in state courts until the Supreme Court here in Kentucky in Fisher v. Commonwealth, which is 620 Southwest 3rd, was a murder case at the Southwest 3rd 1. It was a murder case here in Hardin County. And during the course of the evidence that came into this case, the court permitted conversations that occurred between one of the defendants and an inmate. And in those conversations, that individual not only implicated themselves, but others in the crime. And so the question before the court is, could that evidence, that conversation, which implicated not just one of the defendants, but two of them in the crime, could that come in? One, it's not testimony, which is what the restrictions that Crawford has put forward. Conversations of this sort are not testimony. 804B3 under our rules of evidence allows testimony to come in and implicate not just the person talking, but others that they reference in the crime. If they can show that the conversations they have implicate criminal conduct. And so in that particular case, that person's conversations about their role in the murder and the role others had can come in and implicate and be evidence against not just that defendant, but also the other defendants are referenced. And so other rules that you may have the state of mind exceptions. the rules of evidence will come into play in this trial, whether it's jointly, as we were requesting, or severance. There's going to be legal issues and constitutional questions this court will deal with that guide all of our activities, actions, and evidence presented to this jury. This, whether we have a joint trial, as we're requesting, or it's separate, there's going to be evidence directed right at Mr. Brooks, statements of co-defendants in this case. I think that's what the point that I wanted to make, that some of these statements that they're concerned about are going to come in, I believe, and we'll properly prepare that for the court with arguments and briefs. But I believe they will come in and will address his role and the roles of the other individuals that are involved in this crime. Thank you.
Yes, certainly. Got it.
The judge promise will be brief. Be very clear. Our position in response to the government is we do not believe under any circumstance they introduce any portion of either phone calls that Steve Lawson made to mother, where you have those where he is talking to some extent about some of the things you've heard here today, talking of continuing, we believe, be hopeful that he's going to get immunity, whether they introduce any portion of these grand juries, the last two, where there are statements that you've seen the end result of. We have under due process to get into these other statements. That is unduly prejudicial to us. It confuses the issues. Aside from the 410 issue. With the 410 issue, of course, then there's no question that it's a violation of due process. But it's a violation of due process. It's all of this stuff, we cannot rely on the limiting instruction. That's what Taylor says. So it's not as simple as simply saying we're not introducing. That's what's not said there. They're saying is, well, we're not introducing Steve Lawson statements against Brooks Houck because the court is going to say, hey, jury, don't worry about it. This is not against Brooks Houck, it's against Steve Lawson. But we have to be able to explain how it got there. That's what this is all about. There's no way we can get a fair trial with these other two, given what I've showed you. With regard to what Mr. Lasowski said, what the law is yes, whether it's a joint trial or a separate trial, and even in a separate trial, we'll have future litigation about any sort of statement made by a co-conspirator. First of all, you'll have to make a determination whether or not there was a conspiracy. And obviously, the court has already found beyond a reasonable doubt that Steve Lawson is a liar. So that is a question the court is going to have to answer. First threshold is whether there was ever a conspiracy with these people. Any. Second question that the court would have to answer is was the statement made in furtherance of a conspiracy? So for example, going back to my hypothetical, if I called Steve right now and said, Steve, we're gonna go rob the Fifth Third Bank in Louisville when we get home, that's a statement made in furtherance of that conspiracy. If I'm sitting in the police station after Steve and I got caught robbing the Fifth Third Bank, and I say something about, well, it was Steve's idea to rob the Fifth Third Bank, that is not in furtherance of the conspiracy. So Jim's right, we're gonna have to litigate what statements made before any of these police interrogations may or may not have been in furtherance of the conspiracy. But talking about things after the fact to other people are not made in furtherance of the conspiracy. They're just statements. It's statements made to further the ends of that conspiracy. That potentially, if there was a conspiracy, may be admissible. So they're really separate issues, and one really has nothing to do with the sentence issue. Thank you. I appreciate the time.
Counsel, I believe, and I'd like to hear, I guess, from Joseph Lawson still hasn't presented his objection to the consolidation motion. I've heard now from Steve Lawson and I've heard now from Mr. Houck. I believe we have Joey Lawson set for July 18th.
Yes.
Were they going to address that at that time?
Which I think we can. I don't think they want, and I'll have to check, and I'll get back to Your Honor. I don't think they wanted him present. But their motion, I don't want to speak for them, but their motion is mainly premised on redactions. They want to see the redacted statements before they made their mind up on what they were doing. But we can address that with them on the 18th. We can get a date, either do it that day or shortly thereafter, and I'll check with them this week and see and get with Your Honor and them and figure that out.
Well, I certainly think I should take into consideration what that co-defendant has
Yes.
to say also before
Yes.
making a decision on this. So at this time, then, pending that hearing, the court will get a decision out as soon as it can after I've had that hearing. All right.
Yes.
Anything else we need to take up at today's date?
I don't believe so. Judge, I'm gonna go ahead and I'm gonna send an email out to all the parties. We've had our assistant go back through and compare what we got from various agencies and what went out. And it looks to be either complete or substantially complete. There may be a few little things, like we send stuff out every once in a while that we find. But she's going back through and comparing file with file. But at the end of that, I'm gonna ask everybody to come, to set aside some time and come to the office. I mean, go through it, because I really don't want to end up in a situation where somebody goes, I don't have this. And so we're gonna, and it'll be unredacted. I don't mind the attorneys looking at unredacted stuff. So I just want to make sure, once we get past the severance joinder issue, and we can all start sitting down and having them come to the office, just compare with what they got with what we have. Because it's real easy to miss something. And I'm just gonna be honest with Your Honor, and I think defense can tell you, when you open up a file, there'll be 100 sub-files, and you open up a sub-file there'll be another 100 sub-files. So it's just, and it was all intermingled, all three Barstown cases. So we had to go through each of those sub-files and weed out, or redact. So that would be it though.
And if counsel, when we get finished, I'd like to talk to you on chambers a little bit about venue for a little bit
Yes.
today before we
Yes, sir.
leave, okay? So I'd like to talk to you all privately. All right, that concludes today's hearing, and thank you all.